Call the case NRA 968.02 sub 3 complaint 24 JD1. May I have the appearances, please?
Your Honor, I'll start. Attorney Eric McLeod, who appears on behalf of Rick Van Domelen and Pamela Burke, who are the recipients of the subpoenas that we're moving to quash today.
Okay.
Kristen Schrank appearing on behalf of Alliance for Animals and Dane for Dogs.
Wayne Hsiung appearing on my behalf, Your Honor.
And Stefan Sykes appearing on behalf of Dane for Dogs.
And Rebecca Robinson, president of Dane for Dogs.
Ishmael Ozan, Dane County District Attorney, is also present.
And Mr. Van Domelen is also here by Zoom, Attorney McLeod's client. I think he referenced that, but I wanted to ensure that for the record. Okay, we're set today for a motion that Mr. Van Domelen and Ms. Burke have filed regarding the quashing the subpoenas that were issued in this matter to them. Attorney McLeod, you do obviously have standing to represent your clients in this matter, so I'm going to let you proceed with your motion, and then I'll hear from the other parties.
Thank you, Your Honor. I won't obviously restate everything that's contained in the motion to quash, but let me just quickly summarize. Mr. Van Domelen and Ms. Burke received subpoenas seeking records that actually belong to Ridgeland Farms, and they're seeking records related, obviously, to this proceeding. We moved to quash for a number of grounds, but I think the best way to summarize the basis for our motion to quash is as follows. This is a proceeding under section 968.02 sub 3, which seeks a criminal complaint against Ridgeland Farms, permitting discovery under section 80507, which is the basis for the subpoenas that were served on my clients. Permitting discovery under that civil discovery statute would allow a petitioner to file a petition seeking a criminal complaint against a particular party, regardless of whether there is sufficient evidentiary support, and then seek discovery from that party in an effort to support the petition. That's directly in conflict with the purpose of 968.02 sub 3, which is a narrow exception to the broad authority vested in district attorneys to make criminal charging decisions. If there is indeed sufficient evidence to support a criminal charge in a particular instance, and the DA declines to prosecute, then a private party can file a petition under 968.02 sub 3. However, a private party does not possess the authority that a district attorney has to conduct an investigation into whether a criminal charge should be made. And in fact, as we noted in our motion to quash, a district attorney's authority to investigate has greater limits than section 80507 would allow. A district attorney's authority to issue a subpoena for documents arises under section 968.135. And as we noted in our motion, under that section, the DA must seek the issuance of a subpoena from a court and first make a showing of probable cause to obtain that subpoena. By issuing a subpoena under 80507 or the rules of civil procedure in general, the petitioners here seek to exercise power greater than that available to the district attorney. Also, by seeking to subpoena records at this stage of the proceedings, the petitioners are taking fundamentally contrary positions. They claim that the evidence referenced in the petition establishes probable cause. That's the basis for this petition and the hearing that the court has scheduled. Yet they seek records from the target of their petition in an effort to establish probable cause. If the petitioners claim the need for evidence from Ridgeland Farms in order to establish probable cause, then their petition ought to be dismissed. I'll simply restate the request that we made in our motion, Your Honor, and that is these subpoenas should be quashed. There's no legal authority for civil discovery to be conducted in this type of criminal proceeding along the lines of what they seek. And I will leave it at that and answer any questions the court has. Thank you.
Yeah, thank you. Attorney Ozan, are you taking a position on this motion?
No, Your Honor.
Thank you. All right, Attorney Schrank, on behalf of the petitioner, Dane for Dogs and Alliance for Animals, I'll hear your response.
Thank you, Your Honor. First, I would just say that this is not a criminal proceeding. Yes, we're asking the court to appoint a special prosecutor and would hope that down the road there will be a criminal proceeding, but this proceeding itself is a special proceeding. It is not a criminal proceeding. I mean,
Well,
simply,
but my fundamental issue with the issuing subpoenas in this matter is that essentially you're seeking a probable cause, as we know, under the case law is a lower standard, obviously, than if this matter were a complaint were issued and this went to a criminal complaint proceeding. At this stage, I mean, the danger of granting a request such as yours is what would prevent anyone from simply alleging an offense and then using court subpoena power to try to find facts to support that. I mean, it seems to me that's a backwards way of looking at it, and it's really not the way that things are done in civil cases or criminal cases. I mean, probable cause is established, and then once probable cause is established, you have the power to seek additional facts that would ultimately support you in your burden of proof stage of the case or the higher burden of proof stage. But at least at this stage, I'm looking at the case law and in looking at the statutes, both criminal and civil. I really I don't see authority for at this stage of a proceeding, and I understand this is a special proceeding, to give you the relief you seek, which is to subpoena and force the testimony of the Ridgeland Farms veterinarians. So if you'd address that issue, because I think that's the big issue here.
certainly, Your Honor, 80507 does grant authority for an attorney to act in this manner for special proceedings, which this is. The court, after we filed our petition, which, although we're not acting under 968-135, which requires district attorneys and attorney generals to show probable cause, our petition and the amended petition lay out a plethora of evidence, which could be construed as probable cause, in our opinion. We requested with that petition for Your Honor to appoint a special prosecutor. The court now has ordered a hearing after that petition was filed. And so now it's our responsibility as the petitioners to put forth evidence at that hearing. We have a plethora of evidence already. We're merely trying to provide Your Honor with the most the most possible evidence we can at this point. So we're trying to comply with Your Honor's request for us to come with evidence and demonstrate that a special prosecutor should be appointed at the hearing that's now scheduled for October 23rd. Obviously, we can't act under 968-135 because, one, it's not a criminal proceeding, and two, we're not the attorney general or a district attorney. I understand there may be concerns about the fact that individuals, citizens could bring these types of cases and try to get subpoenas this way in the future. However, 80507 does grant the authority for us to do this in a special proceeding. And just because the legislature has deemed that district attorneys and attorney generals need to show probable cause, but hasn't made that same requirement in 80507 doesn't mean that that Your Honor shouldn't allow us to do this here. That's a legislative issue.
But isn't, and I understanding this is a special proceeding, but isn't essentially 968.02 sub 3 asking or directing the court to step into the shoes of a DA, essentially, because it's a mechanism by which the parties can ask for the court to issue a criminal complaint. And isn't the court, at least at this stage of the proceedings, essentially acting in that position of a DA or an attorney general in determining whether a complaint should be issued?
We're in a difficult position because, we're doing this because law enforcement and the DA has failed to enforce the laws, in our opinion. And so we're just at the stage of probable cause. So we're just asking Your Honor to appoint a special prosecutor who then could act in the manner that a district attorney or attorney general would. The purpose of the hearing that we're going to be having in October is to determine probable cause. And as the petitioners, we must establish either the presence or, for the sake of the alleged future defendant, lack of probable cause by the presentation of that evidence. To not allow the ability to subpoena in this circumstance would leave Your Honor with an incomplete presentation of the available evidence.
Attorney Hsiung, do you wish to weigh in?
Yes, Your Honor. Briefly, I would say that Your Honor is in a similar position to a district attorney. However, the judge in the court, unlike a district attorney's office, does not have the plethora of opportunities to engage in investigative procedures, such as executing a search warrant, commissioning officers, whether of an investigator with the DA's office or a sheriff for the county police, to engage in further inquiry. And the statute is quite clear that in a special proceeding, a civil attorney can issue a subpoena of this sort. I'd add further, my understanding of the subpoena was actually issued by the clerk of the court after discussion in our initial hearings before Your Honor, and therefore 135 just doesn't apply at all. Having said that, some of these discretionary factors do weigh on all of us, and I understand the court's concern and the moving party's concern about fishing expeditions. I would say there are a number of constraints placed on the issuance of a subpoena of this sort. First and foremost, to the extent a civil attorney is making a frivolous request, they can be subject to sanctions. So both Section 802.05 of the Wisconsin statutes and the Wisconsin Supreme Court have indicated that where there's frivolous conduct, an attorney can be sanctioned, and a moving party can be sanctioned for frivolous requests. Secondarily, I think the court does have the ability, in response to the motion to quash a subpoena. And to the extent these are unreasonable or oppressive demands, the court can certainly say that a subpoena is inappropriate. And so to the extent a moving party in a proceeding of this sort is making that sort of frivolous request, there are multiple bases upon which a court can interfere and stop that process before it even starts. I'll just comment on two things briefly that the moving party brought up as well. First is that the granting of an issuance or the issuance of a subpoena in this case would give the petitioner greater powers than a DA. That is just very far from the truth. For one, a DA can file a criminal complaint. A moving party in a petition for a special prosecutor absolutely cannot. So the moving party is claiming that we have greater powers than the DA when, from just a basic jurisdictional, statutory, political perspective, that is very far from the truth. The entire reason we bring this petition is because we do not have the same powers as a DA, and we're depending on a court to make the right decision when the DA has, for whatever reason, declined to do so. And just one last comment about these particular requests. These requests are extremely narrow in scope. We're not asking for evidence beyond the very limited allegations that we already have extensive evidence about. And while I agree, and we submitted our petition, that we have more than enough evidence to kind of meet the threshold of probable cause and even beyond a reasonable doubt, the key thing from our perspective is, even if this court were to permit the filing of a criminal complaint and appoint a special prosecutor, there's some statute of limitations issues. The special prosecutor, if appointed, is going to have a limited amount of time to collect all the evidence that's necessary. And finally, the court, in exercising its discretion, may want a complete picture of the evidence from all perspectives and all evidence that's available. And so for all those reasons, I think the requests here are limited in scope. They're very reasonable. They're narrowly tailored to the three specific criminal allegations made in the petition. And the subpoena, therefore, should be issued.
Thank you. Attorney Seitz, do you wish to be heard?
No, Your Honor, I have nothing to add to Attorney Schrank and Attorney Hsiung.
Okay, Attorney McLeod, final word after you've heard.
Yeah, just three very short points, Your Honor. First, we're not arguing that the petitioners seek greater power than the district attorney in general, just greater power in the context of issuing subpoenas and obtaining documents. pursuant to those subpoenas. That's our argument. As to the argument that was made about seeking sanctions for frivolous conduct, I think that question would arise in the context of the petition itself. A subpoena recipient would not be in a position to determine whether a subpoena it receives is frivolous. The underlying petition is the thing that would have to be addressed, and we don't have standing to challenge the merits of that petition in any respect, and that issue has already been determined in this case. And finally, I'll just summarize the prior argument that we made, and that is the authority to seek discovery in this type of proceeding has to be understood in the context of the narrow exception that applies here, which is the district attorney has general authority to make charging decisions. What's sought here is, a private petition seeks a criminal charge, and that decision, we believe, needs to be made entirely on the basis of the evidence they have, not discovery that they might obtain once they file a petition. So that's the summary of our argument, Judge. And again, happy to answer any question the court has.
Thank you. Excuse me. Well, as the parties know, this is uncharted territory. There's not a lot of authority on 96802 cases. Specifically, there's really nothing precedential from Court of Appeals or Supreme Court that would give this court any guidance on this issue. So it's essentially a matter of first impression. The hearing that we're going to have next month is a probable cause hearing. And the subpoena was served under 80507, which is a civil procedure statute. But the issue is essentially in a 96802 procedure. While I do acknowledge that it's a special proceeding, it is essentially asking this court, I believe, to step into the shoes of a district attorney or an investigative officer on behalf of the district attorney in issuing a complaint. I appreciate the comments made about how the court does not have the same investigative tools that a DA would have, but at the same time, my concern is that in a probable cause hearing, probable cause hasn't even been established yet. And to make a ruling that somehow parties could just file an action and then come into court and request to subpoena documents and individuals to build a case of probable cause seems backwards to me. Essentially, if probable cause is determined at the hearing next month, and a complaint is issued and a special prosecutor is appointed, then of course all of those investigative tools would be available to the petitioner. But at least at this stage, the issue is whether they can meet the probable cause standard. I do not believe that the issuing a subpoena to parties who basically have no standing in this case, as Attorney McLeod pointed out, and which is obviously the case. I do not think that comports with with proceeding in this type of case where probable cause has to come before investigation comes. And as evidenced by the statements by the petitioner in this matter, there is, they claim, overwhelming and sufficient evidence for probable cause at this stage. Allowing a subpoena of these the Ridgeland people, I don't think is appropriate. And it's also potentially, just given the proverbial opening the floodgates type of argument, I think that it would be unreasonable to allow parties to petition the court for a finding of probable cause and then allow all the discovery to occur prior to that hearing. For those reasons, I'm going to grant the motion to quash the subpoenas for the Ridgeland veterinarians. Attorney McLeod, you can draft an order for my signature to that effect. We will proceed on the merits of this matter next month, and I will see you here in person on October 23rd at 9 a.m. We've scheduled this matter, excuse me, for a day-long hearing. Anything else today, Attorney McLeod,
Nothing further, Your Honor. Thank you.
Attorney Schrank,
No, Your Honor.
Attorney Hsiung,
Nothing further, Your Honor.
Attorney Seitz,
No, Your Honor.
Attorney Ozan.
Your Honor, I'd just like to note for the record, my office has not received a referral regarding, I believe, the charges that plaintiffs seek. We have not made a charging decision, so I think no matter where we go in accusation or an assumption that the district attorney has decided not to act in this matter is premature.
So you're taking the position that regardless of how we proceed in October, you're going to be making the argument that the petitioners cannot meet that prong of the 96802 procedure, where indicating that the DA has not made a decision to charge.
At this point, we have not received a referral or an investigation regarding this matter. Now, I know this matter was sort of connected to another decision and case that we did charge and were moving forward on, but dismissed. But we have not received a referral or a charging decision request regarding actions of Ridgeland Farms.
Okay.
So at this point, I'm just saying it's premature for the prong that the district attorney has not acted or will not act.
Okay, well, obviously, the parties in this matter are now on notice. Thank you for that declaration, Attorney Ozan. Attorney Schrank, Attorney Hsiung, Attorney Seitz, you have notification now from the DA's office that they're taking that position on the 96802 procedure. Obviously, we will cross that bridge when we get to that point, but you're on notice that will be that position in October. Okay.
Thank you.
Your
All right.
Your
Yes.
Honor, just given what DA Ozan just said, would Your Honor entertain a subpoena to DA Ozan then? Because it's my understanding that there have been.
This is not the place where I'm going to make an advisory opinion on whether or not I would have entertained subpoenas against the district attorney. Obviously, if you have any motions that you want to make, you can make those and I'll decide them, but I'm not going to essentially give an advisory opinion on what I would entertain or not entertain at this stage. All right.
Understood.
Thanks, everyone. We're adjourned.
Thank you.